Hello, everyone. This is Tom Fox, and I would like to welcome you to episode 186 of the FCPA Compliance and Ethics Report. Today, I have a real treat for you. I have David Kotz. David is a managing director at the Berkeley Research Group and has recently released a new book, Financial Regulation and Compliance: How to Manage Competing and Overlapping Regulatory Oversight. David has a distinguished career at the SEC and other government agencies, and he uses this in addition to his interview of several subject matter experts to talk about the myriad of regulatory agencies, what you should do in an inquiry, what you should do in enforcement action, and what you should do in an internal investigation. I think you'll find this very interesting. He gives a lot of good insights into the workings of the SEC, and the compliance practitioner, the anti-corruption compliance practitioner, may not be aware of really the scope of what the SEC does. The episode comes in at just over 23 minutes. I hope you will find it interesting. Thank you very much for listening. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today, you are in for a real treat as we have David Kotz. David is a managing director at the Berkeley Research Group, BRG. And David has this week released a new book entitled Financial Regulation and Compliance, where he talks about how you respond to different areas of financial regulation and compliance. He interviewed me as part of his research for the book, but it's much broader than the FCPA, and indeed it's really I think a roadmap for every compliance practitioner in a variety of industries and disciplines to think through not only how you do things from internal investigations, dealing with regulators, the decision to self-disclose, examinations, and probably even internally dealing with your boards of directors on complaints and other issues. So with that somewhat long-winded introduction, David, thanks a lot for taking the time out of your day to come visit with us.
Thanks for having me.
David, why don't you tell us how you came up with this idea on your book and your view of what it's about as opposed to mine?
Sure. So prior to working at BRG, which is a consulting firm and / expert witness firm, I spent many years in the federal government, primarily as Inspector General of the Peace Corps and then the Securities and Exchange Commission for over 4 years. So I had the unique opportunity to be the IG of the SEC during the financial crisis, and dealt very often with Congress in connection with the implementation and the writing of Dodd-Frank. And so when I left government, I thought about, given the impact of Dodd-Frank and the impact of the regulatory structures that are in place, and the fact that there are very often overlapping and competing regulatory oversights. And so I thought it would be helpful to write a book for a compliance professional to try to deal with all these different competing and overlapping regulations. And one of the main themes of the book is that every regulatory agency is different. They have different motivations, different approaches, and I saw that firsthand at the SEC. Also, as IG of the SEC, I dealt with a lot of the other financial agencies such as CFTC, FDIC, etc. Us IGs of the different federal financial agencies got together very often to share ideas. And so, I realized that there are great differences between how these agencies interact. And as a compliance professional, you really have to deal with them separately. You have to deal with investigations from the SEC differently than investigations from the CFTC, for example. And so I thought putting together a book that provided firsthand expertise and advice for the compliance professional about how to deal with the myriad set of competing concerns and overlapping regulations would be a helpful thing. And so in writing the book, I dealt with, initially just about the jurisdiction, the different jurisdictions of the different regulators, talked a little bit about corporate governance, talked about whistleblower complaints, and then went into very specific advice on defending SEC examinations, FINRA examinations, National Futures Association examinations, and then also enforcement actions from the SEC, from FINRA, from the CFTC, from the NFA. And then I have a chapter about participating in the regulatory comment process, chapter about FCPA, and about internal investigations. So the idea is it's sort of one-stop shopping. If you're a compliance person and you have to deal with all these overlapping issues, you need to really have some understanding, certainly, of all these and how to deal with them. And so by this book, providing my information with the use of several experts, including you, on the FCPA chapter, it really provides some helpful information for a compliance person so that they're fully versed with all the competing issues that they face on a daily basis.
David, I'd like to explore with you how you used the outside experts. Certainly, you interviewed me and took extensive notes from that interview. How did you use other experts, similarly or in different avenues?
Yeah, and so what I tried to do was, I had a lot of thoughts from my time in the government, but because I really wanted to provide very specific practical advice for folks, I wanted to get further information. So, for example, there's a chapter in there about SEC examinations, how to defend an SEC examination. So I went to somebody who not only worked at the SEC as an examiner, but also was a full-time consultant who advised companies on how to defend SEC examinations. So they saw things from both sides, and they could give very, very practical advice about what exactly you do and what is the approach of the SEC examiners. I have a chapter on CFTC enforcement actions. How do you defend an action that is brought by the CFTC? For that, I found someone who previously served in a very high-level role in CFTC enforcement while at the government, and then has also defended folks from CFTC actions since leaving the government. And so I really wanted to get into the nitty-gritty, get into the details of what the best approach is to use using these different experts. And, I had tremendous assistance from these folks, interviewed them, wrote up their advice, incorporated my thoughts as well. And I think it's really unique. It's almost as if, you're getting sort of free legal regulatory advice from the particular people in that field that would most know about it. For FCPA, of course, I went to you because you are well known as being an FCP guru and expert. And, this is the kind of thing that people wouldn't normally get, I think, unless, there was a whole book written by that individual person. This way, you get discrete chapters with expertise on a wide variety of areas.
David, the anti-corruption compliance practitioner may not know what an SEC examination is. Could you explain what that is?
Sure, absolutely. So the Securities and Exchange Commission has authority to conduct examinations generally against broker-dealers, investment advisors, those kinds of entities. And they essentially come in and they examine your books and records. They interview folks within your company. And depending on how it goes, there could be very severe repercussions to an examination. So, they could make a finding that you've done something improper and require you to remedy certain deficiencies that they've identified, or they can refer the matter to the SEC enforcement division for an actual investigation and potentially an enforcement action against them. And many of the SEC's enforcement actions come from exams. I dealt with this quite a bit in the context of the Madoff investigation that I did when I was at the SEC. So I did an investigation of why the SEC missed the Madoff Ponzi scheme. And in that case, the SEC conducted numerous exams of Madoff and his companies, really with an eye to determining whether there was fraud associated with his operations. Of course, there was. and of course they didn't find it. But since that date, the SEC has sort of revamped its examinations, and when you get a call from as a broker-dealer, an investment advisor, that the SEC is knocking at your door, it can be a very nerve-wracking thing for a compliance person. And what I try to do in that chapter in the book, which is chapter 4, is to talk about practical approaches to dealing with SEC exams and making sure that the matter doesn't escalate to something even more negative for the company.
David, you have a chapter entitled How to Defend an SEC Enforcement Action, and you talk about several things I wanted to ask you about. On one of the headings, it is converting an inquiry to a formal investigation. Can you explain that process from the SEC's perspective?
Sure. And so the SEC, the first part of the SEC process is just simply an investigation. They want to try to look into something. And they start often with what's called a matter under inquiry, which is basically an informal investigation. They're just looking at it. They get a tip or complaint potentially from someone. There's some information that they learn about in an examination, or they just see something in the news very often that is looks like it's potentially problematic. And so they open this informal inquiry. And while they have the informal inquiry open, they can do research, they can learn things, they can ask information from the company in a voluntary way, but they don't have subpoena authority at that point. They're just sort of looking around to see if there's anything worth going further. But then there's a process if they believe that there is something there and it is important for them to conduct an official investigation. Then they convert the matter to a formal investigation, and they do that internally within the SEC. There's a process where they write out an action memorando, and it's sent to the commission, and the commission authorizes them to go forward. Basically, the commission looks at what the potential evidence is and sees if there is something that's really worth investigating here. It's very, very likely that if the SEC enforcement folks feel there is sufficient information to investigate, that formal order is approved. And then the formal order will then provide the SEC with subpoena authority. So they can subpoena documents, they can compel interviews, and they go through a formal investigation process. As that investigation process goes forward, at a certain point in time, if they feel there's a basis to bring an actual enforcement action, which is essentially go to court and sue the company, then they have to go through a similar process where they ask the commission for authority to do that. In that case, it's also very likely that if the enforcement folks want to bring a formal action, that they get approval from the commission. It's a little less likely than just simply converting it to a formal investigation, because there are times where the commission doesn't feel it's appropriate to file a lawsuit. But these are very important and unique parts of the SEC enforcement process that companies defending themselves need to be aware of in order to do their best to limit their exposure and liability in these cases.
David, what is the Wells process, and how does that relate to SEC enforcement?
Sure. And so the Wells process also is a very important part of the SEC enforcement arena. Basically, the idea is that the SEC moves forward with an investigation when the SEC is thinking about actually suing a company or an individual, that they give that company or individual an opportunity to present their side, and that not only the SEC lawyers who are going forward with the case hear that side, but the SEC commission and the commissioners themselves hear it, which is very important because, if you have SEC lawyers and they're investigating the case and they want to bring an action, they're probably pretty convinced. But in the Wells process, you have an opportunity to make your case to somebody else, to somebody who's more impartial, to somebody who could potentially side with you. And so there's a process where there's something called a Wells notice, which is a document that the SEC provides the defendant that basically says, we intend to recommend that you be sued. Then they allow a Wells submission, which is a document that the defendant then provides to the SEC and the commissioners saying, here's why we shouldn't be sued. And then there is potentially also a Wells conference where the parties get together and sit down and talk about the case, and the defendant gets an opportunity to present their arguments. But as I talk about in the book, there are very specific arguments that you should be making in a Wells submission and potentially others that you should not. So, for example, a lot of times a defendant or defendant's lawyers will come forward and, give a sort of very, very strong argument. There's no possible claim here. This case that they brought is a complete joke. There's no potential liability at all, and here's why. And I think, that approach often falls on deaf ears at the commission and before the commissioners, because I think there is some assumption that the SEC is not going to bring a case that has no merit whatsoever. And so what I talk about in the book is what is the best way to assert your arguments but not do it in a way that you lose credibility in terms of going so far. Often in these cases, defendants' lawyers will accuse the SEC enforcement folks of bad conduct or some kind of vendetta. Again, those kinds of arguments often fall on deaf ears. I think it's important to sort of pick your battles wisely and try to make the most credible, strongest arguments you can make. And also keep in mind who your audience is, that your audience is not necessarily the people who have been investigating and litigating the case. It's these other commissioners who may have a more open mind. And one of the expert that I use in connection with that chapter is a guy named Brad Bondi, who's an attorney in securities enforcement cases, but also previously worked for a commissioner at the SEC and had an opportunity to read a lot of these Wells submissions and participate in a lot of these Wells conferences. Once the Wells conference in submissions are over, then the commission decides whether to go forward with the action against the particular individual or company, or whether to potentially come up with a possible settlement in lieu of filing a lawsuit.
You have a chapter on conducting internal investigations. What did you come up with in that chapter in terms of recommendations or at least lessons learned that you saw that compliance practitioners could use going forward?
Sure. One of the most important things that I stress in that chapter is, again, the issue of credibility. And so, very often when you have an internal investigation, they're either done in-house or they're potentially done by counsel for that company who has been representing them for many years. Now, there is certainly a place for internal investigations to be done in-house. There's compliance groups that do it, particularly if they are investigations that are not of such a serious nature. But if this is a very, very serious matter that is being investigated, potentially firm threatening or potentially leading to an enforcement action, what I stress in the book is it's important to make sure that whoever is doing the investigation be credible. And often if you have your lawyers who have represented you for many years conducting the investigation, the SEC or the Department of Justice would not necessarily view those as credible. They'll view them as sort of tethered or tied to the company and not really give a lot of credibility to what the investigation finds. So I think it's important to make sure that whoever you're hiring to do an investigation is completely impartial, has no previous relationship with the company, doesn't have to be a law firm. There are lots of investigative firms out there that do investigations. I've done investigations over at BRG. And the idea is that whatever you want to present to the government as your internal investigation, you want it to be credible and you want it to be taken seriously. And while your either in-house counsel or outside counsel for many years, may conduct an investigation that is completely unbiased and impartial and may find all kinds of helpful information. If it doesn't have credibility, it really damages what you're trying to achieve. I also talk about different ways of obtaining information and strategies for conducting interviews. I talk a little bit about sort of my background. I was the Inspector General at the Peace Corps before I went to the SEC. At the Peace Corps, generally the people I was investigating were volunteers. Peace Corps volunteers, often young people, often people who really had very little experience being investigated or really being even in these types of situations. And so the approach that I used at the Peace Corps was sort of the sort of cop, just between you and me approach, where, we sat in a room, I explained the importance of telling the truth, nothing was recorded or even notes taken, and just tried to explain to the individual that they needed to sort of fess up with what happened. After that, I would have them, I would write out a written statement and have them sign it. When I got to the SEC, I started using that approach, and it completely didn't work. The SEC is filled with lawyers. Almost everybody who works there is either a lawyer or an accountant. They are much more familiar with these situations. Many of them are litigators, and so they're often in depositions. So when I did interviews at the SEC, I basically did almost everything under oath with a court reporter, because lawyers understand where there's a court reporter there and it's under oath, you have to tell the truth. If you're just having a sort of casual conversation with them, they're less likely to be honest and forthright. So I talk in this chapter about internal investigations how you have to use the right approach in the right situation in order to obtain the information that you're trying to get as part of your investigation.
Very well put. Very well put. David, unfortunately, we're getting near the end of our time, but I did want to give the full title of the book, which is Financial Regulation and Compliance: How to Manage Competing and Overlapping Regulatory Oversight. I think this is going to be a fabulous and, frankly, well-needed addition to every compliance professional's bookshelf. The myriad of overlapping jurisdictions and types of investigations that any compliance professional can be faced are really addressed in your one volume, and I really congratulate you for putting this together. It's available on Amazon.com. Is there any other sites it's available as well?
Yeah, also if you go to Wiley, which is the name of the publisher, you can get it there as well. And appreciate the kind words and appreciate your very helpful input in the FCPA chapter.
And David, finally, if someone wanted to get in touch with you directly on anything, questions they may have based upon this podcast, or want to get in touch with you for another reason, could they do so? And if so, how would they do it?
Absolutely. I would love to hear from people. Let me give you my email. It's hdkotz, HDKOTZ, @thinkbrg.com. That's THINKBRG.com. Feel free to email me anytime. I'd love to hear from folks, and very excited about the book coming out.
Well, you should be. Once again, this is Financial Regulation and Compliance: How to Manage Competing and Overlapping Regulatory Oversight. If you're an anti-corruption compliance practitioner, you're an export control compliance practitioner, or you're a financial compliance control practitioner, this is a book for you. It's really exhaustive, authoritative, and I think one that we've just barely touched on several of the important chapters, but this is something that everybody needs to take a look at, and I highly recommend that you go out and buy it, because I'm going to do so. So with that, David, thanks a lot for taking time to visit with me, and we look forward to continuing the conversation.
Thank you. I enjoyed it.
Hello, everyone. This is Tom Fox. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I hope you will consider coming to my FCPA Masterclass, which will be offered in Houston on September 10th and 11th. If you are interested in either creating or enhancing a compliance program inside of a corporation, why not come learn from one of the top FCPA compliance practitioners in the United States? The price is very affordable. If you need any more information on it, please give me a shout, tfox@tfoxlaw.com. Thank you very much for listening.